When I was in law school, we had a visit from a top executive at Coca-Cola. He said that every tangible piece of property at Coca-Cola could burst into flames. And the next day they would have every dollar they needed. If all they had to do was pledge their trademark portfolio.
Hello, I'm Bruce Berman, the host of Understanding IP Matters, a podcast series that looks at how IP rights enable creators and businesses to achieve and how they impact lives. Listeners who followed Season 1, thank you. Remember that all Understanding IP Matters episodes are available wherever you stream podcasts. We encourage your comments and welcome suggestions for topics and guests. Please contact us at explore@understandingip.org. Gene Quinn is CEO of IP Watchdog, the most widely read publication in the intellectual property field. With more than 300,000 monthly visitors, IP Watchdog's go-to coverage is a must-read. Quinn is also a writer, patent attorney, and leading commentator on innovation policy. He has twice been named one of the top 50 most influential people in intellectual property. Quinn has advised inventors, entrepreneurs, and startup businesses, and is highly regarded as a teacher and speaker. Sue Decker covered patent litigation and policy from Washington for Bloomberg News for more than 2 decades. She retired this year after 35 years in journalism. Decker was one of the very few business reporters ever to have a dedicated IP beat, and the first woman. Prior to joining Bloomberg in 1999, she spent 5 years covering crime and the courts for Florida Today. The patents beat exposed me to every industry, she says. Litigation provides a window into the growing pains and struggles of an industry, while patents tend to give a glimpse into the future. Good morning, Sue and Gene. Welcome to Understanding IP Matters. It's good to have you with us this Friday morning.
Good morning.
Morning, Bruce.
You're both products of Central New Jersey, I believe.
I'm Ocean County girl, Tom's River.
Yeah, I'm Monmouth County from Freehold.
Okay.
Oh my gosh. Yeah, we're practically neighbors.
Exactly. Yeah. And I knew that. That's my first question. So are Bruce Springsteen and Patti Smith and John Bon Jovi. So is there something in the water that we should be aware of?
Yeah, well, Bruce Springsteen's from my hometown. Yeah.
Is he really?
Yeah. My cousins went to school with him.
My cousin went to school with him.
Really?
Huh.
Your reporting on IP developments poses unique challenges, legal, technical, and financial. It isn't easy making IP developments, lawsuits interesting. What are the greatest challenges? Sue, let's start with you.
Partly it's getting editors to appreciate it was my biggest challenge. People tend to think patents are very complicated, in large part because it has all its own vernacular. I mean, it's the only area of law that has its own appeals court, but it's actually not that difficult. There's always a story behind the patent suits. There's always a story of the inventor. There's a story of the industry. There's a story of how it affects consumers. There's always a story behind it. It's just finding that story, the why of it all.
Yeah, no, I completely agree with Sue. You know, and in patent cases, they can be extremely complicated. The technology is very difficult and thick. And one of the things that I've always tried to focus on are the issues that people can really understand and grasp. So I've always gravitated to like the unfairness, like the procedural unfairness in issues. You know, a lot of these cases, they could go either way. Is this invention? Is it obvious? Is it not obvious? I mean, that gets into very thick technical issues with experts and stuff, and it goes over people's heads. But whether or not the inventor had an opportunity to actually tell their story in front of a judge, you know, that's a real issue, you know, and sometimes they don't get that opportunity, you know, in various tribunals. And I think that strikes people as unfair. And that's the story I like to tell.
Has the interest of business and investors in IP developments, has it changed much in, say, the last 20 years?
Oh, definitely. Definitely. When I first started in April 15th, 2001 was when I officially became the patent reporter for Bloomberg. And trying to get anybody interested in the topics was very difficult. Even investors didn't care, analysts didn't understand. And what really changed was the BlackBerry case. If you go back then, everybody had their Crackberry, and there was this question of whether the Crackberry was going to be taken away from them and things like that. And that's when people started to see why patents are important, which was my plaintiff cry for many years. And you started to see a different attitude towards patents. Some people looked at them as a force for good, that they were a way for companies to protect their ideas, to protect their work. Others saw them as a force for evil, that they were getting in the way of all sorts of things. Usually your attitude always depended on which side of the V you are in the lawsuit.
Gene, your audience is primarily legal, while Sue, yours was primarily financial. What can you safely assume today that they know and don't know when reporting on IP developments?
Oh boy, that's a big question. I'm just going to be completely honest with this answer, right? And it's probably going to offend a lot of people, I suppose. But try and write at, I think, a level of maybe a high school education, maybe, you've had a little bit of college and you're interested in the topic, but that you're not steeped with knowledge, right? Because some of these cases, even if you are a patent attorney, they'll have issues that are not your everyday issues, because the everyday issues aren't particularly interesting. They're everyday issues because they're well settled and nobody really argues or talks about them. I write for I think the person who's interested but not deeply knowledgeable about what I'm writing about.
Sue, and for investors, what do they know today?
Well, Bloomberg, don't forget, Bloomberg also gets picked up as a wire service. So we get picked up in newspapers as well.
That's true. And you've written for Bloomberg Business Week as well.
Right? As Business Week as well. And so it's kind of the same thing as Gene does. You're trying to, you want to write it in a way that is obviously accurate, but also comprehensible. I almost never use the word injunction, for instance, or certainly not about prosecution. I would never use the word prosecution because people don't understand the definition of prosecution in patent world versus the rest of the world. So you have to write it in a way, they always do the tell it to mom or tell it at a cocktail party is kind of the attitude that you have to have toward it.
I like the cocktail party idea with the drink in your hand.
Yeah. Yeah, no, and that's so true. I mean, because that's about what I always tell people is, somebody who's interested in knowing more about what you're saying and probably has some basic knowledge about what it is that you're talking about. Otherwise, they wouldn't be reading an article about patents. It's not like somebody's going to read a story about Apple or, some, above the fold type thing in the New York Times or Wall Street Journal. So it's somebody who's going to have some interest or knowledge on some level that, patents are important to something or have some basic knowledge. So cocktail party is a good example. But Bruce, there was one thing that came to mind when Sue was talking, and this maybe is a function of, me being the editor for so many years and also having limitless space on the internet, so sometimes I actually will write an article for an audience of one, and it'll be, I want to write this article because I really want somebody on the federal circuit to see it.
Mm-hmm.
So it'll almost be like a Dear Judge article, or I really want a staffer to see this, or something like that.
Do you know they will see it, or how do you know they do see it?
Well, you never know for sure, right? But I have some reason to know that our articles go around, because people inside the Beltway read certain things, right? They read the Wall Street Journal, they read the New York Times, just to keep up with everything that's going on. But then they read the stuff that matters to them, so they'll read me, they'll read stuff that Sue writes, they read stuff that you write, particularly, if they're on investment subcommittees and things like that, right? So they really do look to try and stay up with what's going on. So there is a bit of a difference in some of what I do, because I do a lot of opinion stuff as well as kind of, straight by the book.
Yeah, and my audience is very different because I'm not getting into a lot of the nitty gritty of the law. I'm focused on trying to get the people who are not interested in patents to read them. So I would do a story about some of my favorite stories that I've ever done didn't involve patent disputes that you would think of. The smartphone wars were interesting, but not particularly interesting. But finding the story among others cases that people would be interested in was always a fun part of the job.
Not many people want to hear about IP policy or,
It is tough. That is the hard part. One of the big things, of course, is the U.S. competition with China on an intellectual and technological level. So for IP policy, if you could kind of put it back towards that, then it would be interesting. But the arguments over one-on-one, it was just
it's too obscure.
A little bit too obscure.
But if it has brand names involved, big tech and big dollars, a case, an award, a potential award, then people they like that. They want to read about that.
Sure. Like names make news, it's celebrities, things like that. But I've done stories that have actually done a lot of impact that weren't brand names. One of my favorites was about the American obesity epidemic. And what was happening was there was tons of innovation in the diabetes monitoring market, which led to patent suits. So instead of starting with the American obesity epidemic to get to patent suits, I started with the patent suits to explain the obesity epidemic. So you can use patent suits for a lot. And you quoted me saying accurately, is that it really does give a window into a growing pains of an industry. People only fight in patent fights over things that matter. If a market is growing or contracting significantly, you're going to have battles. If a market is stagnant, there's nothing to fight about.
There was one thing that just came to mind, probably a random thought when you were talking about, Bruce, you never know exactly what you write that is going to be the read the most. And sometimes I think the things that I'm most proud of that I think are really important get read the least. But I wrote an article, this is many years ago, and it was probably, I think, the most read article in a single day. It was during the Obama administration. They passed a bill that dealt with funding for, rare diseases, research into rare diseases. And I think we were the only outlet that covered that. It got passed like on a Friday morning on voice vote or something, and we covered it and nobody else covered it. And I think like every parent that had a child that had rare disease read that and forwarded it around and everything. So, sometimes what you write really, you don't know it's going to resonate, and it does. And, and then when you see something like that, and to me, that felt really good. It was really exciting that really touched a lot of people. I don't know, maybe it's sappy, but I felt good about that.
No. And I, one of the things that I would get all of these emails from people who wanted to know when a drug was going to go generic. And they would ask me, because of course the litigation is a prime driver of when it's going to go to generic. And people would send me emails and say, thank you for writing about this. I don't know how it works. Please explain it to me. And or thank you for writing the story, letting me know when I can get a, lower cost drug. So it's exactly, you don't know what's going to touch people. And it's always nice when it does.
We met 20 or so years ago. You had said you covered the courts and there were investors, sometimes hedge funds, who would call you seconds after a case was decided or a specific day in court, development in the case. How do you respond to that? I mean, you can't give information to an individual, but you can write about it.
I would usually say, please let me get my story out first. I would send a headline and the phone would start ringing, and I would say, let me get it out. And they would call me and they would ask for details. And I would say, okay, I'm going to post. It would sometimes drive what I would update. I would answer their questions and updates. If it was just a procedural question, like, what's the next step? oh, there's an en banc, there will be an en banc filing. What's an en banc? And I would tell them that I would be okay with, but I would never give them any information that wasn't publicly available already, just because I didn't want to be unfair to someone.
But they would certainly try. I think.
Oh my God, yes.
They love that information edge, right?
Yes.
But I think, Gene, I think IP Watchdog is read for that as well, no?
Yeah, and it was many years ago, and I won't say what case it was, and I wasn't writing about the case because somebody had hired me to consult with them on what the likely outcome of the case was going to wind up being, and I predicted exactly the outcome of the case and exactly which judges were going to be on which side, and then the stock went down, and I contacted the person after the fact, and I'm like, I asked them, can you just explain to me how this happened, And he said, oh, well, we were factoring in that this was going to be a $3 billion verdict upheld by the federal circuit. And I said, oh, I see what happened is you forgot to ask me the critical question. And they were betting at the time on 6 times the highest verdict the federal circuit had ever upheld, and it's like, the odds of that happening were 0 at that point. And they're probably a $3 billion verdict being upheld now is still probably close to 0,
Yeah. Every time there was a big verdict, I always have to do a story that had something like, there is no way that the federal circuit will ever uphold a verdict this large.
Mm-hmm.
They cannot,
right.
for political reasons.
Yeah, eventually they will uphold a $1 billion verdict, but I'm not sure we're there yet. Maybe we are. I mean, we'll know in a couple months or a year. They got a couple of them coming up.
Yeah, but when the Cisco decision came out recently, I was like, okay, I knew that was going to be overturned. The only question was, what issue were they going to hook it on?
Right, exactly. And then when these things go down and they go back up, and it's like ping pong. And then it's sort of like with the Apple and Samsung, it keeps going up and down and up and down. And every time there's a new decision, the amount awarded to the patent owner keeps going down.
But the old adage is, I think, still fairly true: buy on the rumor and sell on the news. And I think a lot of professional investors do that. They hear something that sounds great, but you buy on that. News comes out, whether it's accurate or not, doesn't matter. It's old news.
When I first started covering patents, there was like this, they called it the Decker effect in the newsroom, is I would write that someone got sued for patent infringement and the defendant's stock would rise. Like, what is that all about? And the editors would just laugh. And I said, the only thing I could think of is that the investors were saying, well, if they're copying it, it must be that good or something. And I have no idea. But it was people didn't understand what was going on. You talk about the one case you're like, I thought the stock was going to move up and it moved down. I had a case where I thought a ruling that I thought the stock was going to fall like precipitously, and the ruling comes out and the stock soars. And I'm like, what's going on? And they're like, oh, the one patent that was upheld but not infringed on this company, but it was upheld and they're using it against another company. And that's one we care about now because this earlier company is no longer in business or something. And you have to keep up with that. And so the investors had to watch not just the litigation, but also what was happening in the industry.
Yeah, no, I know it's really complicated. I mean, Bruce, I don't know how you do it with the following all the investment stuff. I mean, because that's like a science in and of itself.
Well, it's funny. I've been looking at it. I started out in investor relations many years ago, so I had that basis of looking at balance sheets and talking to a lot of analysts. But they knew nothing about IP. Almost not. Only analysts who knew about IP were pharma analysts, and maybe a couple of the big brand guys who were aware of trademarks. But they want to learn, and they're smart, and they can learn very quickly. That's the good news. Gene, IP Watchdog publishes every day, sometimes multiple times. That's unusual in the IP world. There are a couple of others out there, IP Law 360. How do you and your staff keep up with the news and determine what should be covered?
One of the best things I've ever done is I hired Eileen McDermott as our editor-in-chief, and she has just been wonderful. And so she manages the publication completely, and we work together very, very well. One of the things that we try and do is we try and cover it absolutely as much as we possibly can. And I think if you read everything we publish you can stay abreast of the entire industry in a week. And I say that with some confidence, like there's got to be always an asterisk, because nobody can capture everything that goes on, right? But on Mondays, we do here's what's going on in DC. It's sort of a summary of, what's going on in think tanks, what's going on in Hill and the hearings and everything. And then on Fridays, we publish something we call Barks and Bites, which is, okay, here's all the stuff that we really wish we had time to write about, but we didn't really have time to write about, with quick summaries and then links to other people who did write about those things, and then in between, we write about, as many of the hearings that are substantive that we can get on, and as many of the Federal Circuit cases as we can. I try and write about anymore. I really focus my own stuff on usually opinion pieces, because we have other people who write more about just the facts. So I'm trying to interject more of an opinion column.
What was your most challenging story?
The whole, and this is not a single story, but like all of the stuff about 101, it continues to feel like we're just shoveling water back into the ocean. And I say that over and over again. We're getting nowhere. We're getting absolutely nowhere, and we're actually getting worse, right? Because now it's like a drive shaft. Something that, like, if I threw at your head, you need to go to the hospital if you didn't duck, is not patent eligible. Like, because it's a law of nature. No, it's a drive shaft. You can grab it. You probably can't even lift it. Most people can't lift it. It's crazy, but it's like Monty Python for patents, and so that's the thing that like just wants to make me pull my hair out.
So what's this most challenging story you recall working on?
Mine is a topic as well, but I would say FRAND, which I love writing about FRAND. I love learning about FRAND. It's so consequential to so many industries, and not even the people who are arguing about it really understand it. And the rules are changing constantly. You've got this confluence of antitrust, intellectual property policy, and there's just so many issues that are, geopolitical debates going on. So to me, the giant logic puzzle, trying to figure out who's sitting next to whom, I find fascinating and intellectually stimulating.
And that goes along with, I guess, SEP's standard essential patents.
Yeah, exactly. Yeah. Standard essential patents, and figuring out what's fair, reasonable, non-discriminatory. And the joke always is that, in the US, it's only RAND, reasonable and non-discriminatory, because I don't care if it's fair. But now the US is starting to call it FRAND as well.
Hey, Bruce, can I kind of maybe put a little bit of an asterisk here? Because one of the things that is really, really frustrating with patents, I think, is we did a hard left turn when the Supreme Court said you can't get an injunction easily.
eBay.
Market change, yeah.
Yeah, and eBay, because what that fundamentally did is it changed the patent right, and it changed the whole industry, and it made implementers emboldened to say, well, go ahead and sue me, and maybe you win, maybe you don't win, and litigation is a risk anyway. And I think that because I fundamentally think the law works best when it encourages people to do deals outside the courtroom. And I think that changed that balance, and it forced people into the courtroom.
I would agree to some extent, but going back to our both from Central Jersey, I often say that everything I need to know about patent law I learned from covering mobsters on the Jersey Shore.
Oh my God, that's so true. So true.
Really is. And one of the things you learn is that bad case makes bad law. And I think that there are bad actors in the patent world. There are, the closets in Texas, and I'm not saying all the Texas cases, but the closets in Texas, which I think not only are abusive toward the defendants, but I think they're abusive towards the inventors. I think the inventors kind of get the shaft on those. And they're mostly like the personal injury lawyers looking for something to do. And people were upset about that. And instead of taking a scalpel and trying to figure out how to deal with the closets in Texas, they decided to take a sledgehammer. If you know the facts of the Merck Exchange case or eBay case, they were not traditional NP. They were a failed company, basically, that got eaten by the big dogs. And so they took a sledgehammer to a real problem, but instead of looking at it as a scalpel, again, because as you mentioned many times, Jane, the Supreme Court knows nothing about patent law. They took a sledgehammer to it. And that's the problem. I do think there's a need to address some of the abuses in the patent system, but having covered the law for 30 years, a decade with not patents, there's abuses in every aspect of the law, but you need to address it incrementally and with some nuance that the Supreme Court lacks.
Right. And there's not just abuse, there's a lot of stupidity. I mean, like the Mayo case, the claims in that case, I mean, my God, what was the patent owner doing? I mean, no, I've never heard, and that is not my technical field of expertise, but I have never heard anybody.
Tell us a little bit about Mayo. What is
so in Mayo? The Mayo case, that's the case that essentially comes out and says that, I believe it was a blood test case, and they did a blood test, and they said, based on the results of the blood test, they were going to decide how to adjust your medication, right? And that really was about it in the claim. It was very simple claim. I don't know how they got it through the patent office. And it was adjusting medication based on the results of a blood test or some kind of a diagnostic test. And people look at that and say, well, like, how can that possibly be patentable? And I've never heard anybody in the sciences on any side say, oh no, you're missing the critical point here. There's this nuance. There's no nuance to that claim. That claim should never have been issued. And it goes up to the Supreme Court, who doesn't know anything about this. And they say, oh, well, let's just kill it under 101. When in fact, the claim was not new or it was obvious. You didn't need to destroy the entire patent system with 101 to get rid of a stupid claim.
Well, and that's where the whole question, when 101 is considered a threshold question, and does that mean that it's a question that you ask first in a case, or is it a question that just tells you how big the threshold is? And there was a lot of I think it was Judge Mayer who was saying, look at everything else first before you look at 101. It's only after you address everything else that you would look at 101. And then there's the argument, no, you look at 101 first. And that's perhaps part of the issue, is at what stage in the proceedings do they look at patent eligibility? But Mayo, I would add, is a perfect example of bad case making bad law.
Oh,
because
my God.
There are legitimate diagnostic tests that need to be patented.
No, absolutely.
Well, maybe we need to run a primer for the Supreme Court justices. On
my
IP.
God, yeah.
Ugh.
I
thought Sotomayor's husband, I think, is a copyright attorney, if I'm not mistaken.
No, Sotomayor's ex-husband is Kevin Noonan, who's a biotech patent lawyer, very well respected, and a terrific guy. No, it obviously started covering patents well before Sotomayor joined the bench, but you would go to these hearings and it was just, the joke was, which stupid analogy can they come up with that makes no sense, and the whole with the 101, it was like digging, creating canoes out of trees, and I can't even remember all the different analogies.
I know it was ridiculous. The baseball bat was always in the tree.
Yeah.
It was like, oh my God.
It's not a politicized notion. It's not like the Supreme Court is too right or too left to make these decisions. They're just uninformed.
Yes, until you had Gorsuch in the oil states and the oil states case on the judges, the PTAB, it was never politicized. The decisions were never right or left. It was always who could decide what. But until that decision, and that hearing was so different than anything I had ever attended in covering. I had covered every Supreme Court patent case, and that case was the first time I had ever seen politics injected in a patent case. It was usually just outdo you on stupid analogies.
IP owners of all types and orientations agree on three things. No matter, they may disagree on a lot, but they agree that IP is misunderstood, it's frequently undervalued, and it's often infringed. Almost no one else gets that in the real world. How important is it that audience understand this dynamic?
I think it's critical, because particularly in younger people, the reason I say that is because what you learn when you're young then starts to becoming ingrained in you, and I think, the Napster generation just grew up with music is free, and that really affected. No, music is not free. A lot of somebodies have spent a lot of time putting that together. In a former life, I was co-owner of an independent record label. And so I know everything that goes into it. It's not just the person who wrote the music and the band who plays it. It's there, there's a sound engineer, and then there's all the marketing people who do this. And then there's the booking agents who book the band. And then there's, and you can go on and on and on and on and on. If you're just stealing this, you are really just disrupting an enormous amount of commerce and hurting jobs. It really does.
I would also blame the big tech companies because they have spent so much time denigrating patents under what I refer to the George Carlin law of patents. My stuff is stuff and your stuff is crap. And so they, if you go back, I remember, when I first started talking to Microsoft about patents, and they were very, very down on patents. Patents are horrible. Patents cause all sorts of problems. And then they started obtaining patents, and then it became like a whole different attitude, and they changed. And then, Google, which was founded on a patent, was like, oh, all software patents are horrible except ours. Understanding that when they make those announcements, they're not making them from any deeply held belief. They're making them from their economic viewpoint is important to understand, that I think a lot of people don't realize.
Yeah, and I totally agree with that, and I think that one of the things that we've learned, and I don't know how this factors in exactly, because the big tech and others, and I suppose the social media platforms, they're big tech too. They become so good at getting their message out, and their message is very simple. Patents are bad. Patents get in the way of sharing information. Sharing information is good. Hakuna Matata. And those messages.
Patent licensing is bad. Patent licensing
Right.
is.
Well, but all of these things get in the way, and it on the surface it sounds right, particularly like most recently now with the vaccine. If you're not familiar with how patents work and the business of things, it is alluring to think that patents got in the way of people actually getting the vaccine, which is just nonsense. I mean, that's just not true. But
yeah, I wrote a couple of stories on that, and I got editors pushback that actually didn't believe me.
No, I know. And so, and I don't know about you guys, because you don't live in the Northern Virginia or DC area. And I know that we get different TV commercials than the entire rest of the country. But we had nonstop patents are bad and patents are killing people during the pandemic. And they were with cartoon characters.
Mm-hmm.
Yeah, well, Jane, I live in DC, and so I've seen them, and it was so fascinating to see bus stops. And,
yes.
City buses, everybody else in the world has city bus ads are all about the local news network or what TV show's coming on. And in DC, all the buses and bus stops have political ads. And it was fascinating to see. You did have a couple of companies like Qualcomm, and this isn't obviously in the biotech or pharma space, but you see a couple companies, Qualcomm, like put ads out about patents are important, but for the most part it was. And their audience are the politicians who don't ride buses, but they're staff members.
Why doesn't the patent troll label, that meme, it won't go away? It's just here, and
it's a soundbite. It goes back to the whole thing about their message is so easy and it's so short, and the message on the pro IP side requires a paragraph.
Well, you have to. Do you know the story of how that word came about?
Yeah, it was Peter
Yeah.
Detkin, wasn't it?
No, it
No?
wasn't. It wasn't. It was a typical example of a man taking credit for a woman's work. What happened was Intel was sued.
Right.
And I don't remember exactly what happened, but they got caught in some sort of shenanigans in court, and they were fined or somehow chastised by the judge. And the Wall Street Journal called and was writing about this. And Chuck Malloy, who was the spokesman at the time, said, well, it doesn't matter. They're just a bunch of extortionists. It was a small, failing or small company that had sued them. And so the company sued Intel for libel, for calling them extortionists. So Peter Detkin was involved, but there was a group of all the Intel lawyers got together, and Ann Gundelfinger, who was their trademark lawyer, so understood branding, came up with the idea of a troll as someone who stands on the bridge blocking. So it was actually Ann who came up with the idea. Peter Detkin, ran with it. So if you know that the term came about, and by the way, the case settled, of course. But if you know that the term came about as trying to find a way to criticize somebody without being sued for libel after being caught doing bad things in trial, then it makes it a little more understandable.
And it's funny because there was that guy in New Hampshire who sued for being called a patent troll, tried to sue for libel and defamation, and he lost.
Yeah, and if there's one thing you're going to not do, is flood a state with lawsuits in the state where the senator is the head of the Judiciary Committee at the time.
Right.
So,
and the slogan, and I lived in New Hampshire for a number of years, and the slogan is live free or die,
Microsoft, again, going back, was originally calling them pirates. And that term, Microsoft wasn't apparently as good at marketing as Intel was. But it hit at the time when you had, you go back to the 90s and the dot-com boom. The patent office was completely unprepared for all of those patents that were coming up, and they didn't understand and they acknowledged that they didn't understand what they were doing, and they were kind of rubber stamping everything. And then you had the dot-com bust, and you had all of these people, tort reform at Texas. So you had all these personal injury lawyers with nothing to do. You had all these bankruptcy lawyers rolling around Delaware, and saying, these companies are going bankrupt and all they have are these patents. Let's see how we can get some money out of the dregs of it. So you had Intel coming up with this name. At the same time, you had the rise of this litigation of failed dot-coms, of patents that were pretty problematic. I think everyone would agree that they were problematic patents. And so it was kind of a perfect storm thing.
Final question, because we're just about out of time. Where do you see media coverage of IP going? What's the future going to look like, Gene?
I don't know. I mean, I had thought that when I was embarking upon IP Watch like that, we would see more things like what I'm doing, where you have somebody who really deeply understands the subject writing about that, because doing news and collecting news, and it is very costly for these big outlets. And I think we are going to continue to see the big outlets suffer and smaller outlets flourish, because the smaller outlets have the luxury of being able to focus. Now, I do think at some point in time, what we'll see is, and I don't know how fast it will be, because in the IP world, this happens really quick, where you see big firms acquire the smaller firms, and then they realize, well, that wasn't such a good idea. Then they break up. And then some time goes by, and the big firms forget that they didn't really like it when they acquired the smaller firms. So they acquire other different smaller firms, and it keeps going back and forth and back and forth. And so, but I think you're going to see that in the news media. I think you're going to see some of the larger groups, media groups, acquire some of the smaller niche stuff, the more nimble. Now, whether they'll be able to stay nimble, that'll be a different thing. But I think the nimble media is the future.
Well, I'm looking at more as from the reporter's perspective, and I think that you're still going to have fragmentation. I mean, you have the drug reporters will peek in and write about patents when it's involving drug, and then you'll have the tech reporters peeking in, and And I think that they don't quite understand that they miss the whole picture. They miss the big picture of what's going on. And so it's, I think, much easier if you're only tapping into it from your particular industry to kind of be swayed by the big companies or the activists, either one, positions on things without seeing nuance that you get from seeing an overview. And there's very few news organizations that look at IP from a business perspective as a patent thing. You know, IP 360 and Bloomberg Industries, they look at it mostly from the law side of things. Bloomberg Industries is looking more to kind of integrate the law and the business, but you still see the coverage incredibly fragmented. I don't mean to toot my own horn, but people ask who my competitors were, and I'd be like, well, I've got thousands of them. You know? I've got thousands of them.
There seems to need to be a higher level of literacy, a certain amount of minimal information that business people, lawyers too, perhaps in a different way, but that at least investors should know about IP, which they don't seem to, which is kind of frightening.
Well, there is a coterie of investors who only focus on litigation. They're called event-driven investors. And so they will look at not just IP, but other types of litigation, like the lawsuits against the FDA or some agency, you know, EPA or whatever. And so they actually have, I would say, a fairly well-developed sense of what's going on because they're looking at it at a high level. But
they're looking at risk too, of course.
And they're looking at the risk and looking at it from the perspective of how is this going to affect a company's bottom line. So I think that outside of that small group, you're still going to see very fragmented coverage and understanding of IP.
And anything else to add, Gene?
Well, the one thing, just based on what Sue said and what you asked, is I think there's an alarming lack of understanding of IP in the C-suite, particularly at the CEO level. You know, a lot of these companies, the major value, like maybe as much as 80% of their value is in IP. Many years ago, the perfect example is, and I think this is still true, when I was in law school, we had a visit from a top executive at Coca-Cola, and he said that every tangible piece of property at Coca-Cola could burst into flames and burn to the ground. And the next day they would have every dollar they needed. If all they had to do was pledge their trademark portfolio and they could rebuild everything, you know, and that's not an exaggeration. We all know that that's true because that's where the value is. It's the trademarks and then it's the recipe, right?
I think the C-suite, especially CFOs, are afraid of IP. The intangible assets, they're hard to value. Brands are less hard to value, but certainly patents are. And
but if you are a CEO or CFO and you don't understand where 80% of your corporate valuation is, what the hell are you doing?
Right.
And why are the boards okay with that?
Well, certainly the drug companies and the medical device companies know that.
Right. Yes.
But it is, part of it is just the terminology, the vernacular that's used, that people, it's like the revenge of the nerds. The patent world has is so insular, where they have their own terms that mean nothing in the real world. And as a result, they've kind of caused difficulties for the C-suite or other people to understand. And I always said that my job was not as a reporter, my job was as a translator to take all this stuff and explain it to humans, because, you know, it's not, they don't often talk to each other. They don't understand each other.
Well, thank you both very much taking time out on your summer Friday to talk about IP and your reporting, which is you're two unique individuals in this regard, pioneers, if you will. And this was an important and useful discussion. Thank you both.
Great, thanks, Bruce, and thanks, Sue.
Thank you, Gene.
Understanding IP Matters is brought to you by the Center for Intellectual Property Understanding and its subscribers. To hear other episodes, visit understandingip.org. Follow CIPU on Twitter at Center for IP and on LinkedIn. This episode was produced and edited by Nathan Tower and Aaron Devereaux at Nonsensible Productions. Content conveyed on this podcast is for informational purposes only and does not reflect the views of CIPU or its affiliates.